Hi everyone, welcome to episode 79 of the Immigration Lawyers Podcast. Thanks for tuning in and welcome to 2019. Hopefully a great year. We're already having a bizarre new year in 2019 with the government shutdown and all the immigration things that are affecting our practice and our clients. But before starting this episode, I wanted to put out a reminder out there about the immigrationlawyerstoolbox.com. It's a great tool I've created for immigration lawyers to access it, to get information about new events, new laws, get practice pointers, get basic information about terminology and definitions in the immigration system, and much more. The videos of this podcast are also posted there for you to view. And recently I've recorded and published a new series which is detailed reviews of L1A decisions by the AAO, each lasting more than an hour, and they also come with California CLE credits. And what I've realized is many, probably over a dozen states have reciprocity with California CLE requirements. So if you go to the website, it'll list the states that potentially have reciprocity, and you can always look at your home state's requirements and your home state's bar for how they accept those and how you can get those CLE credits. But it's a great way to learn about L1A at a very high level and at the same time take care of those CLE requirements. The newest review that I've published are the L1A decisions from April and May 2018. Without further ado, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Well, thanks for tuning into this episode. I wanted to start by thanking Nicole in Chicago and Jennifer in San Francisco, two fellow practitioners that listened to the show and reached out. Thank you so much for listening and getting involved and communicating with me. I'm glad you're able to enjoy the show. Feel free to always contact me. My email is info@jqqlaw.com. I enjoy talking to fellow practitioners and seeing what they're up to. So there's 9 or 10 things I want to talk about in this episode, and they're all kind of random, but there are some topics I thought it would be important to bring up. This podcast is intended for immigration attorneys, so I think stuff that may seem boring to the regular people is much more interesting because we get our livelihood based on this stuff, so it's important to know. First and foremost, California instituted a new rule. It's really based on the Supreme Court decision, or a California Supreme Court decision, that said that contractors that's really about independent contractors and whether someone's an employee or independent contractor, it's rearranged this relationship. And one thing I saw in California, a lot of local businesses here in Los Angeles at the very least, is that some people who are independent contractors are not considered employees. Well, that's employment law. How does that affect immigration? Well, all these former independent contractors are now W-2 employees, which means they have to complete a Form I-9 and tell the government what kind of relationship, what kind of immigration status that they have, and potentially have to go through E-Verify. So what we're going to see is a lot of people who are going to disappear from the map that were independent contractors because they don't have status, or some of them that don't have status will complete the I-9 form and get bogus documents or lie. And worst thing is that they may do a false claim to citizenship. And that, as you know, is the kiss of death in immigration, and it can be a problem. And it's an issue, and it's a topic that's come up more and more, not only at the time of getting a green card, but even towards naturalization, where USCIS officers ask about this. So that's something to be aware of, to tell your clients, employers, whether they're employers, whether they're employees, to not do false claim to citizenship. You may be able to get away with claiming to be a green card holder because there's some interpretation that says applying for a job, with the fake social or saying a green card holder, it doesn't become a problem for trying to obtain a benefit, an immigration benefit. They don't consider it an immigration benefit. But false claim of citizenship, that's not going to work. The second thing that happened last week is there was this big news article, I think it was by the Associated Press, where they started talking about the number of marriage and fiancé visa cases that were approved by USCIS/DHS that were people that were married underage. There's this big hubbub now about child brides coming in and how bad that is. Obviously, children shouldn't get married, and there's sex trafficking, all those kind of issues. But one thing that was kind of confusing about what they're talking about is, there are foreign countries, obviously, that allow marriage with very young ages and with parent consent. Sometimes people are married without even seeing each other. Their parents put this stuff together. There's all sorts of old world thoughts about this. And But the issue is this: for USCIS and the State Department to approve these cases, the regulation as it is that the marriage has to be valid in the jurisdiction that it occurs in. So let's say it happens somewhere in the Middle East, it has to be valid according to the customs and regulations and rules of that nation and that jurisdiction. But also wherever they're moving to in the U.S., a petitioner's residence has to be valid there as well. So for example, if you're doing a K-1 fiance visa and the person's marrying their cousin, like a first cousin, some states don't allow first cousin marriage. So if the petitioner is residing in one of those states, the State Department is going to deny the case, saying when the person moves to, I don't know, Nevada, for example, I think Nevada is very strict on that. They won't be able to get married, so the K-1 fiance isn't valid. But California does allow it. So I'm not sure it's first level cousin or second level cousin, but California is less restrictive on that. So that'll be valid. Now, if someone's marrying a child bride coming here, that may mean that those states don't have any regulations about the age requirement that a person has to have before getting married. And there was some stuff online that said there's a lot of states that don't have any requirements and that kind of stuff. So there is a big issue, and it's kind of judgmental of these overseas countries that have these kind of regulations, but then when you look at the U.S., there's a hodgepodge of kind of messed up laws as well. Obviously, again, I'm not for people really getting married before 30, to be honest, but under 20 or under 15. But it's something that we got to clean up our own house. And I got to take DHS's side on this. They're really making USCIS look bad in all the articles. It's not USCIS's fault. It's not like they're approving of this kind of stuff. They're just going by what the regulation is. So sometimes you need to stand by what they do, because by making them look bad, what happens is USCIS is going to then become more strict on stuff, and that's going to hit our clients who are doing everything legal and not having these kind of issues. So when USCIS has done stuff wrong because of bureaucratic mistakes or because of them taking the initiative on their own and bending the regulations, as they do frequently enough, especially under this administration, we definitely have to put their feet to the fire. But sometimes it's not their fault, and we have to give them some leeway on that. So that was interesting. And there were stats that came out of this article. So they said from 2007 to 2017, there are 3.6 or around 3.6 million marriage and fiance cases. I did the math, and that comes out to 7,000 marriage or fiance visa cases each week. So as practitioners, and this is on the business side, there's 7,000 I-130s and I-129fs being filed every week. So that's a lot of marriage cases. I do 3 to 4 marriage cases a month, and that's enough to sustain a good lifestyle in West LA. So there's a lot of business out there, and that's why you see a lot of these companies creating these online softwares to get into this kind of business, or notarios getting involved, or all these other people trying to do this, because there's just so much there. So if you are practicing, it's really important to put yourself out there to get these cases and not let them go, because obviously 7,000 cases, not all of them are going to lawyers, probably a lot of them aren't. People are filing on their own and making large mistakes that become big problems. For example, my wife was getting her hair done by a woman that was from New Zealand, and they had filed an I-130. She filed for her husband in New Zealand, and they missed an RFE, but they didn't realize it, and the case got canceled. A year later, they contacted USCIS to see what's happening, and they got a denial notice, or the phone they said it was denied. And they're like, oh no, then they refiled and it was fixed. But even a dumb error like that of not getting RFE for submitting photos or something like that will push their lives back an additional year and a half, and cost them another set of filing fees, whereas just having the attorney would have solved the problem in the first place. So that's something to get out there. Know there's a lot of cases to get, and when there's 7,000 cases, there's attorneys that charge a lot for this, a little, but the one thing I'm trying to do is, with these educational materials that I'm putting out, is there's a lawyer for every price range that's needed, and people could go and find the one that fits them. But it's very important for them to have an attorney that's dedicated and is paying attention and knows the regulations, as opposed to just doing it through these notarios who don't. And frankly, some of these lawyers don't either. But the main part of what I'm just getting at there is there's a lot of cases out there, there's a lot of business. So immigration law is still a great opportunity to grow and help people in a way that's going to sustain your lifestyle. Next thing is, the reality of this is bad, because a lot of my clients, I do affirmative USCIS cases where there's no unlawful entry. There's a big issue that the president is pushing, that the people are from Mexico, from Central and Latin America and South America are coming here illegally across the border. When they're looking at the stats, the vast majority of the people here that are here unlawfully come in on tourist visas or visa waivers. They're saying between 600 to 700,000 people each year are overstaying their visas or their visa waivers. Now, I'm not really sure if that stat's real. Some of them might be going back and the system doesn't catch it, or they're adjusting status or lawfully staying here, or they're changing status. I'm sure a lot of these people are here legally and stay legally. But the reality is there's much more people that are coming like that, which means that they're going to start, by having this in the news and so much attention to it, they're going to become even more restrictive at the border, at the visa issuance, at the consulate or the embassy when they're issuing visas. And that's always a big headache, because I see clients going through so much hell sometimes, especially in certain countries, just to get a B1, B2, or at the border going to secondary, when they're not a bad case. They're really going to abide by the rules of their visa category. But with news like that, again, just like the USCIS thing I was talking about a second ago, the CBP and DOS is going to be cracking down on this stuff, and it's going to be a hassle. I'm going to jump ahead of something I wanted to talk about later, because it kind of is related to this. There's on the listserv, on the AILA listserv, we were talking about this incredible thing where people coming here for employment-based cases, L1s, H1Bs, and the like, they work for companies here who's a petitioner, and sometimes these companies will list an address as their office that might be a WeWork office, which is usually a Workshare office, but WeWork also has independent offices that they rent out that people could be there. Someone has said, and people corroborate that they got this, that their WeWork got a letter, their local or the office they were at got a letter, and they informed the applicant and the petitioner that of this letter that said, "I'm contacting you on the behalf of the U.S. Department of State Visa Office. The U.S. Department of State occasionally contacts petitioners involved with non-immigrant visa petitions in order to verify that the information presented to the U.S. Department of State is accurate and valid. The petitioner here indicated to the U.S. Department of State that they are a member of this address." And then they say that they have a list of questions they want answered. Is this a WeWork address? If yes, please answer the following questions. Does a petitioner rent actual space or virtual space? So see, the virtual office becomes a problem. I've heard of practitioners say that they filed L1s with virtual offices, but I would never do that. That's way too risky. If an actual office, how many companies share this space? Approximately how many square feet is the office space? How long has the petitioner been a member? To your knowledge, how many people from the petitioner office use this office space? And that's not fair, because they might not know, pay attention to that kind of stuff. To your knowledge, how often is the office space used? Do you offer virtual and actual office space at this WeWork address? So they're looking into this stuff to crack down. So it's something to be mindful of. I know it's cheaper to get the WeWork address, but don't do it. What I tell clients, especially L1s, is, you know what? Especially if you're doing a new office L1, go get the cheapest office you can find somewhere in like not a good neighborhood. Get it, get the lease, sign up for 6 months. It's still going to be less expensive. Come here. Once the business is operating, it's getting up and running, and you know where you're going to stay here before the filing of the renewal, then go and find a neighborhood that you like to drive to, as close to your home or where the good employees are, and move the offices there. For these new office L1s, you just need to have an office. It's not a requirement it's going to be your continued office, or it's going to stay where you're going to stay forever. You could move, and you should do that, and find an area that suits you in the marketplace that you're in. So that's something that may help. For H1Bs, they're not really going to move like that, especially because they're usually not going to be new offices. But if you get the WeWork address, you need to get a fixed space that has your own desk there, and has your name on the door, that kind of stuff. So if you get a site visit, or the DOS wants to come and check on it, they can. On top of that, I've talked about this before. There was this really interesting documentary that was done by the BBC where they visited the new U.S. Embassy in London. It was a 4 or 5 part series where they go behind the scenes of everything about that embassy. I only watched one of the episodes. That was about the travel ban happening and how that was. It was pretty depressing. But in that one episode, they showed that there was a consular officer in a room that would go and call people based on the DS-160s and the phone number they gave, and just to be like, "Hey, how you doing? We're calling from the U.S. Embassy in London. I just want to see where you're at. Are you still in the U.S. or did you go overseas?" And the person would say, "No, I left." They're like, "Okay, thank you, bye-bye." They're actually calling people to check. I'm not sure how efficient that is. One, people won't believe it's from the Department of State. Secondly, they could lie on the phone. But it's very interesting that they're doing that. And it's interesting, too, if they do somewhat misrepresent or say something on the phone, is that going to record that comes back later for, fraud or misrepresentation and need to fill I-61 waiver? So it's getting crazy about this stuff. And when they say there's 600 to 700,000 people overstaying their visas, the Department of State is going to do this more and more. But then that goes to another topic, and I'm jumping around in the order I had set, but actually this order makes more sense. The government shutdown. Can the Department of State afford to be doing this on a continuous basis? When President Trump came, first he had Rex Tillerson as Secretary of State, and what he did is he gutted the State Department. And then the people who are career service members were just too offended of working for the administration, and they quit. So right now the resources are kind of stretched thin. Now the government shutdown really hasn't affected USCIS because it's fee-based. CBP, they have to keep working there, but maybe they won't do the extras. For example, if your I-94 has a glitch on it you need it fixed, I sent one for correction a week ago and I still haven't had that corrected. So maybe this ancillary stuff they're just not going to bother doing because they're not getting paid. I don't know, but that may be the case. Obviously, EOIR, the courts are shut down except for non-detained cases. Consulates are still operating, and they can't issue visas for things like the EB-5 regional center program. Not the direct investment is okay, but the regional center program they can't. But there's going to be slowing down. There's admin processing sometimes that's required with background checks, and that's other government agencies that may pull back. But the more we get into this government shutdown, and who knows when it's going to be cleared, who knows, by the time I publish this podcast, it might be over. President Trump tomorrow is supposed to be talking about this or something. But even with USCIS and being a fee funded, they still need to use the services of other agencies. So that's slowly going to accumulate and start grinding the system down and slowing everything down and create more of a backlog than it is right now. So like one thing I've noticed, and this is not related to the government shutdown, but the employment authorization documents are getting delayed again. I was getting them as fast as 4 months a couple months ago, but now they're pushing 6 months again. It's really frustrating because the clients are here, they want to get the employment authorization. I have clients who are here on OPT, H-1Bs, L-1s, and they want to continue working because they let that status lapse or that's ending, and they need to work and stuff. So it's a big headache that they're taking this long to issue employment authorization for these kind of cases. Now, this is kind of a random subject that just threw on there, but I saw a news article that said the U.S. fertility rate has dropped, and now we're less than the 2.1% recoupment rate, which is needed to keep the population at the level it is, not even talking about growing. The U.S. population itself, the domestic population, is coming down, but the foreign-based groups are much higher. And really, the way the U.S. replenishes itself is through immigration. Now, when immigration comes, there's people from different cultures coming, and there's argument about that. And I've actually been researching a lot about this issue with regards to the founders in the time of the U.S. Revolution, what they thought about immigration. And I'm going to have a separate podcast on that, go into a lot of detail on that. But their biggest worry was that it's not that people are coming here, they're open to immigration, but if they came in bulk and didn't have time to assimilate, what would happen with the U.S. culture and respect for liberty and all that kind of stuff when these people come from foreign governments or foreign countries and bring back the old school culture of here. You know, things worked out for the most part. It's up to interpretation if it did or not. You know, I come from foreign background myself and I adjusted really well, but some people don't and they bring that. But then again, that's a certain foreign flavor that comes. And that's a whole argument and discussion when having this ever podcast. But the reason why it's really important to either recoup it by having a lot of kids, and I recommend people have as many kids as possible. There's a lot of people who don't like kids or keep talking about, oh, having kids is bad for the earth, or I'm happy without having kids. And God bless if you don't want to have kids, but you know, having kids is great. But on a demographic and economic level, Japan and China are at the not recuperating rate. Japan just because it's kind of I hate to say a weird culture where people really aren't having sex even anymore. It's kind of stuff. There's a lot of documentaries about that where the male-female relationship is breaking down and that kind of stuff's falling apart, and guys aren't really interested. It's kind of its own thing. But in China, the idiotic one-child policy, which just murdered a bunch of babies and all that kind of stuff, has led to a demographic nightmare where you have all these people getting really old and not having another class of people to be able to recoup and pay for the services there to make up for the missing employees that are there. So it's a demographic time bomb that's going to explode. And so this really goes to the idea of how important immigration is. And both Japan and China are countries that are essentially anti-immigrant. Japan is just recently trying to open it up because they realize their labor pool has gone so low. The idea that robots are going to take over is a pie in the sky thing. And Japan, being the most foreign and most forward-thinking and on the front of this robots and stuff, hasn't been able to do it and to make up for their lack of employees or lack of labor. And China is the same. There's only so many people from rural areas that come. And as you're already seeing, there's more people in Vietnam and Philippines and these kind of people picking up the slack of where the Chinese economic engine was going. So there's a lot of talk about China taking over and being number one. It's just not going to happen when the core of it, your labor pool, is that low. and it's not replenishing itself, and you're in a socialist system where they're supposed to, pay into the system so that they support their parents and all that kind of stuff. When you have, single family families with single children, traditionally, they have multiple children to support them when they get older. But when we have two people, parents that have one child, the child doesn't make enough money, doesn't have enough job, or doesn't have work, or just unfortunately passed away or gets sick, those old people, who's going to take care of them? The government's somewhat, well, they don't have the same systems we have here, but that creates more of a burden on the system, on taxpayers, and all that kind of stuff. So that's just an interesting thing that really goes to immigration, the importance of immigration, and what we do as immigration practitioners to recoup the population loss that naturally occurs to sustain the economic engine that we have. Even with the robots and all this kind of stuff coming in, the automation or thinking things automatic, it's still not going to be enough, at least in the next 50, 100 years, I believe. So it's really important what we do to bring people here, and all echelons and all parts of the system. There's this idea that people have to be, physics professors to come to the United States. We have need for all sorts of people to come here. There are people that come here as dishwashers and grow to great heights. And so it's not really about that. It's really having a mix of people who come here without the expectation of taking from the system. I've had people call me and like, I want to file for asylum, and how soon could I start getting taxpayer benefits? Literally, they'll say this stuff, and I'll just hang up the phone. I don't want to deal with that. I understand when I come here, better life, and sometimes needing support. I understand that. But we don't want people to come here just to get a piece of the system. We already have enough people in the U.S. that do that. It's really just coming here, want to experience liberty and see how you can put yourself in a place to thrive in that environment. And there's billions of people across the world who would do that happily. Now we can't really let billions of people here, both politically and feasibly, it's not going to work out. But it's important what we do is to help that system to bring it here within the regulations that we do have. The next thing is about the Department of Justice. What can you say about the Department of Justice? The EOIR, the poor immigration judges, and I hate to say the poor immigration judges, they're feeling the brunt of their own masters over there, how much they don't give a damn about them and the way they're treating them. But the Department of Justice issued a report on terrorism and immigration, and it was just full of crap, essentially. And people have called them out on this, and they've been all this stuff, and they've even acknowledged that the stuff in there was incorrect, but they're unwilling to correct the report. So what happens is certain other news agencies take this report and they cite it, or people on their Facebook pages cite this report that's bogus and has all sorts of errors in it. And so it's just a terrible thing that's going on under this administration, that they let the DOJ get away with this. It's just not right for the government to be spreading this. And talk about fake news and all this kind of stuff. A lot of the stuff going after Trump, I think, this Russian stuff is garbage, and they just hate because people hate him. And I gotta say, okay, I understand that. But when the DOJ comes out and puts out false numbers about terrorism, all this stuff, to try to justify their certain actions, that's some garbage. So it's important to know if someone comes out with this report, they've already acknowledged that there's errors in it, they're just not fixing it. And I don't know really how to push back against that, how to undo that, but that was just something interesting that came out. Now, a lot of people file for the diversity visa, the green card lottery. Most of the time they don't hire lawyers for that, they do it themselves. But the interesting thing is, and I don't do diversity visa that often unless someone contacts me and just begs, like, I want you to be my lawyer for it. Usually it's adjustment of status cases I do, but I was contacted by someone, we're doing a foreign-based diversity visa case, and all of a sudden, when we submitted DS-260, we got a notice to email the documents to the KCC, the Kansas Service Center, KCC, Kansas something center. I don't know what the second C is about. But they want us to email the documents to them. And, traditionally, there's a few posts that are going through a pilot program where you email documents to them. For example, Iraq is one of them. I think CDJ was one of them. They're taking it out. But for the diversity visa program, they're like, I think it's maybe potentially since November they started doing this, to email all the civil docs before for them to review before going to the embassy to take the original. So that's something to be prepared for. Have all civil docs ready, so when you file the DS-260 and they ask for that, you get the email, you're prepared to respond to get that all out of the way. Now we're reaching the deadline for the student visa new memo, which said that from August 9th, the 3-year, 10-year bar started applying for people with duration of status, I-94s, which are F and M and J kind of cases. I'm not sure if M is, but I know J is potentially, and for sure F visas, student visas are. So the 180-day mark comes on February 9th, and I'm sure a lot of students don't know this. If they're out of status or mistakenly fell out of status or they did unlawful employment, they're going to be subject to a 3- and 10-year bar now, and that's coming up in a week or two. So that's going to be a nightmare, and we're definitely going to be feeling this in the future, and people are going to call us overseas. They got married, fiancé visas, and then we realized they overstayed and they're subject to the 3- and 10-year bar, and they got to do a 601 waiver. So that's something that's going to be coming up. The last thing I wanted to discuss today was regarding a Ninth Circuit ruling. In the Ninth Circuit, there was a case that happened, I think, last August, and it was about people who sell methamphetamines. And according to the case, and I don't really handle removal cases or people have criminal history, so I have to look into this a little bit. But the case was called Lorenzo v. Sessions in the Ninth Circuit. It held that a conviction for a certain sale of controlled substance in California was not an aggravated felony that would render someone unable to just status or inadmissible. This was because the California statute was overbroad because it includes both geometric and optical isomers, and this is technical chemistry stuff, whereas the federal definition under the Controlled Substance Act only includes optical isomers, not geometric. And this means that the minimum conduct required to violate this statute, and this creates some sort of issues where you couldn't convict someone for immigration purposes, or you could convict them, but the immigration consequences wouldn't be there. And all of a sudden, abruptly, the Ninth Circuit said that we're going to open this up and undo this ruling, and that they're going to look into it. And so that was interesting that that's going to change. It was like an interesting time that they did that. It's kind of bittersweet. Practitioners I see sometimes are like, yeah, our client got some relief and stuff like that, that they're saved from the statute. But at the same time, some of these things, it's like, we do want these people deported. Like, there's sometimes domestic violence cases where someone beats their wife up, and then a practitioner goes to immigration court and tries to argue to keep them here, and there's some sort of loophole and stuff like that. They're like, yay, I got this person off, and it was like, is it really a yay that you got this person that beat up their wife and their child to stay here? Lawyers are not supposed to judge and you take the case, but I don't take all those kind of cases myself. There's always a right to representation, but sometimes it's like, my personal opinion is all drugs should be legal. It should be a health issue and not something that people go to prison for. But as it is, the rules are as they are right now, and it's a crime to do that. So if you're here and you're, committing crimes and you don't have proper status, then you shouldn't do that. Find some other way to make money. Become a citizen first, then start selling drugs. Essentially, not really. Thank you so much for listening to this episode 79 of the Immigration Lawyers Podcast. Please listen on iTunes. If you do, leave a 5-star review, nice words, and a comment. And if you don't like the episode, don't leave any review at all. Also, you can find this on YouTube on the Immigration Lawyers channel. Watch the video of me talking this out. I wanted to remind you of the L1A AEO reviews I put out. If you go to the immigrationlawyerstoolbox.com, it's under the, I can't remember what link it is, but there's a link on the top of the page that breaks down and it says AEO reviews. I also have these practice pointers I put out on a weekly basis, just nuanced stuff about immigration law to remind people of things really that's like, I should know, but then every time I get a case on it, I'm like, oh, I knew the answer to this. What was it again? I have to look in the statute again. I thought I'd just record videos and have the source in the subject line of the YouTube video at the bottom so that, like, you go look into that, remember what it is, and it could come up so you don't have to do all the research again. Just little stuff that comes up here and there that I thought's helpful. And that's about it for today. Thanks so much again. My email is info@jqqlaw.com. Feel free to contact me directly. Add me on LinkedIn. And the website is immigrationlawyerstoolbox.com. Until next time, have a good one. Bye-bye.